is that same man in 2014 changed the law so a lot of Jamaicans who made a little mistake can't get no expungement.
At the recent JLP Annual Conference, the Minister of Justice made some very inaccurate comments about the reform that I had introduced in 2014 as Minister of Justice to the law governing the expungement of criminal records. I have decided to respond to those misstatements and set the record straight in the interest of maintaining the accuracy of the history of this matter. In 2014, after just 2 years as Minister of Justice, I brought a bill to Parliament entitled the Criminal Records Rehabilitation of Offenders Amendment Act. The background to that reform was that as a responsible minister, I had witnessed firsthand the dispiriting and frustrating situation which then prevailed as a result of the very long periods that persons had to wait after they had served their time or paid their fine before they became eligible to have their criminal records cleaned up by the process known as expungement. During that lengthy period of waiting after completing their punishment, they often suffered from not being able to successfully apply for employment or for visas, or indeed to access other important benefits. In the interests of justice, I sought to make their lives better by bringing important changes to the expungement legislation. Those changes that I brought can be summarized as follows. We eliminated the doubling up of the waiting period that persons had to endure before they became eligible to apply for expungement, and we introduced a much shorter period for applying to clean up their record. That shorter period ranges now from 3 to 10 years, depending on the duration of the sentence that the person had served, whereas before they would have to wait for sometimes up to 20 years before they could apply. We also introduced a simplified process for the automatic expungement of offences relating to the personal use of ganja, such as smoking ganja or possession of small quantities, whereas before, anybody convicted of a ganja offence had to go through the full expungement process and endure the long waiting periods before they could clean up their record. We also permitted the expungement of convictions for consensual intercourse between teenagers in boyfriend-girlfriend situations, which previously were not eligible for expungement, a situation which created much injustice. We also cut the waiting period applicable to offenders who are under the age of 18 when they committed their offence, and cut it to half of the period that is applicable to adult offenders. The most serious offences continue to be excluded from the system of expungement, and that remains the situation up to today. I brought these beneficial reforms after 2 years as Minister of Justice. The present Minister of National Security and his government have had over 7 years to bring any further reforms to the system of expungement of criminal records that they think are necessary, but they have done nothing to further improve the system. He really ought to know better than to make inaccurate public statements about the 2014 reforms. But unfortunately, it seems that misinformation is now the order of the day, and that is why I've taken the time to set the record straight. I will always serve the interests of the people to improve their lives and make Jamaica a better and more just society for all our people.